Shaking up the rule of lawyers. Bar councils not to entry of foreign law firms, even if the scope is restricted, will likely drain large Indian law firms of both talent and clients. The name of the author is Berjis Desai. It had all the ingredients of a midnight coup. The new Bar Council of India (BCI) regulations permitting entry of foreign law firms (FLF) were a bolt from the blue for the partners of large Indian law firms (ILF). The announcement came not in the form of a policy decision as is the usual practice. Detailed rules and regulations having the force of law were straightaway unveiled overnight, and that too when all thought that the matter was in cold storage, without even a whisper that something was afoot. Whoever structured these regulations is a mastermind. The regulations do not adversely affect more than 99% of the 20 lakh strong Indian lawyer population. The hitherto vocal opposition has thus been skillfully muted. Foreign lawyers cannot appear before any court or tribunal in India, nor can they dabble in real estate or conveyancing. Hence, the turf of almost all Indian lawyers except a micro minority of transactional law firms remains secure. BCI has clarified that even in transactional matters, FLF can only advise on foreign laws. Of course, for international commercial arbitration conducted in India, even if the law governing the contract in dispute is Indian, the foreigners can advise and argue. Were the nervous managing partners of ILF reassured by the clarification? Not really. In the past, after some FLFs had set up offices in India were compelled to exit following adverse court judgments, many entered into what was euphemistically treated as a best friend relationship with ILFs. The more daring among them set up a surrogate model in India. Such a surrogate firm would be manned only by Indian lawyers and satisfy the criteria for being classified as an Indian firm. However, in practice, such an Indian firm would near exclusively work for the parent FLF and depend upon it for much of its business. This model was fairly successful and still persists. Under the new BCI regulations, this surrogacy may proliferate. The FLFs that will now set up offices in India to advise on foreign law may well have surrogate ILFs next door to advise on Indian law. On paper, distinct and separate. In practice, the client will get a seamless service both for foreign and Indian laws. This is precisely what is keeping the partners of ILFs awake at night. ILFs are not allowed to be LLPs, only as partnership firms with unlimited liability. Every partner is liable jointly and severally for the loss or liability incurred by the firm. This was a major roadblock for foreign law firms to set up offices in India. The new regulations have, with a stroke of the pen, permitted FLFs to be constituted as LLPs, that is, with limited liability. The regulations reveal a steely determination with full government backing to introduce the new dispensation expeditiously. Hence, the applications for registration to be made by FLFs are likely to be processed rapidly. In the current financial year itself, some of the larger FLFs that always had India in their sights will make offers to Indian lawyers. In most ILFs, only about 50 plus attorneys constitute the A team or the super performers who are the most precious asset of the firm. A team members often behave like prima ballerinas and are ready to move out at the slightest provocation. FLFs will target these A teams with substantial increase in tax efficient remuneration, faster path to genuine equity partner status as opposed to playing second fiddle in family controlled law firms, opportunities to move to foreign offices, participation in the international profit pool. Big time poaching of these A teams, including equity partners, may have already commenced. MNCs always prefer to use the same law firms worldwide. Hence, MNC clients in India will migrate as soon as such FLFs set up shop in India. In order to prevent a MNC client from using the competitor services in an important market like India, a FLF that had hitherto no plans to practice in India may also now be compelled to rethink on having a presence here. Of course, some large Indian corporate groups may continue to feel comfortable only with the ILFs. Fees charged by ILFs are likely to come down. However, corporate India is now willing to pay high fees so long as the service is excellent. Many will therefore move to foreign firms to avail a better quality of service. In a nutshell, large Indian transactional law firms are likely to lose both their star players and their star clients. To term these BCI regulations as a major game changer is the understatement of the year. The writer retired as managing partner of a large Indian law firm.